Okay, committee, let's get started. We have 3 bill hearings today. We'll start with House Bill 2351, and I'll open that hearing with Natalie giving us an overview.
Thank you, Mr. Chairman. House Bill 2351 increases the maximum rate paid to appointed counsel for an indigent person. The bill amends KSA 224507. That's the statute that provides compensation for appointed counsel by the Board of Indigent Defense Services. Current law there provides that those attorneys shall be compensated at the rate of $80 per hour, except that the chief judge in the judicial district can negotiate an hourly rate less than $80 per hour for attorneys who voluntarily accept appointments or contract counsel shall be compensated at a rate specified in the contract between the board and the assigned counsel. If the board determines that the appropriations for indigent defense services will be insufficient for any fiscal year to pay those claims that are reasonably anticipated to be filed, then the board may adopt a formula for prorating the payment of pending and anticipated claims. This bill increases that floor rate from $80 an hour to an amount not to exceed $100 an hour on or before June 30th of 2024, and at a rate not to exceed $120 per hour on and after July 1, 2024. And then those current exceptions to that rate, or the way that that rate could change, would remain in effect. And I can take any questions.
Any questions? Well, Representative Carmichael should ask one, but he's not. So have we had this before? And how?
You have, and I will pull up the bill number real quick. I can't remember. It didn't pass, but the contents of it actually made it into a budget proviso. And I'm sure the proponents will probably get into that a little bit, but you have heard this before.
Okay, thank you. Thank you, Natalie. Proponents, Heather Cessna.
Thank you very much, Chairman Patton and the rest of the members of the committee. My name is Heather Cessna, and I am the Executive Director of the Board of Indigent Defense Services. And I am here as a proponent for this bill. It is a bill that you all have already heard. It came through the last session in House Bill 2363, and it does contain the same language. I wanted to make a couple points while I was up here in support of this bill. First of all, we are currently paying right now $120 an hour through a special budget proviso that runs through the end of June 2023. In my testimony, I did ask that we amend the language of this statute, this proposed bill, to essentially pick up that $120 an hour starting July 1st. And going forward, that actually is in line with the governor's budget recommendations for our fiscal year 2024 budget. She's included money to support $120 an hour going forward, and both Senate Ways and Means and House Appropriations have already adopted those governor's budget recommendations. So being able to continue $120 an hour going forward instead of having that 1-year deadline would prevent us from needing a special budget proviso to carry over. The reason that $100 an hour is in here is because at the time that this originally came through in the previous bill, we were only paying $100 an hour. So that's the reason why that's in there. But we're obviously struggling to try to keep enough counsel on our appointments list. Being able to maintain $120 an hour will help us be able to maintain the people that we have currently on our list. So we would ask that you consider supporting us.
Questions, Representative Carmichael.
Thank you. Thank you, Ms. Cessna. There's a reason they don't let me deal with money in this legislature, because I couldn't keep good track of it. We got a fiscal note a little while ago from the Division of the Budget. Have you seen that note?
Yes. So
can you educate me about it? Because it says that by doing this, we're going to save $1,147,340.
Right. And that's at the current language that's in the bill going back to $100 an hour. So if we stay, and we had a discussion with with the Division of Budget about that ahead of time, because they have to go on what the proposed language of the bill is now, even though we know the governor's budget recommendations cover $120 an hour going forward, because that bill hasn't passed the legislature yet supporting that. So that's at the $100 an hour. At the $120 an hour, our current recommendations from the House, the Senate, and the governor will support the $120 an hour going forward for fiscal year 2024 without having to put additional money beyond what's already accounted for in those recommendations. So I hope that kind of clarifies why there was a fiscal note there. And that's just because the language of the proposed bill was back to 100.
That makes sense. Thank you, Mr. Chair.
Representative Titus.
So this only goes to our panel attorneys, not like our public defenders. So they're paid salaries. So this is only for the private appointed attorneys that serve on our panels. And it has helped us bring in additional people onto our panels. At this point, when we do have somebody who can't continue taking cases, the most often cited reason for that is actually caseload. And when they are able to clear their caseloads, they are willing to come back onto the panels. Prior to getting up to $120 an hour, we were having a lot of people turn us down, saying that they just simply could not afford to take cases because they couldn't cover their overhead with the prior $80 or even $100 an hour. We do have a separate fiscal request as part of our budget to go all the way up to $140 an hour eventually, but that hasn't been approved by either of the houses or the governor's budget recommendations. So we may be coming back to see if we can get in another group of attorneys to try to pull in with that higher rate at some point in the future. But at least for right now, $120 an hour seems to be doing a good job of keeping the people that we need on the panels as long as we can. And when they do have to move, it's caseload related and not funds related.
So just to follow up then, I guess while we're here and we're having this discussion and knowing there's a lot of moving budget pieces, this is the right number, or this is a temporary stop to the right number? How would you describe that?
I think this is the right number for us going forward. I think, like I said, we are probably still coming back, whether it's, continuing to advocate the rest of this year or next year for a higher rate, but I don't know how likely that will be to be able to push it up that high. So I think at least right now, it's going to be important for us to put this in statute at 120. That's what we've been paying already. That's what we anticipate paying going forward for sure. And having it as an actual part of our statute instead of doing this in budget provisos will help us educate the court as to what they're supposed to be paying, because trying to point them to the budget provisos gets a little hinky sometimes when we get questions from the judges who are trying to sign off on vouchers. But also, I think it'll reassure the attorneys that this is not going to go away if it's part of our statute.
Any other questions? Thank you, Heather. Oh, which one? Representative Mon.
Thank you, Mr. Chairman. Thank you, Heather, for being here. So you were talking about the one reason why people leave the panels is because of caseload. Obviously, more attorneys on the panel would help spread out the caseload a little bit better. And I think that's obviously something we would like to go down that path a little bit. But the problems you've been having with retaining counsel, is that entirely a budgetary thing, or is it also related to some of the other items we've heard recently about COVID and just the difficulties we've been having across the board?
There are not enough counsel right now to handle the number of or the volume of cases that are being charged by local prosecutors. So we have a separate problem that, like in our public defender's offices, we just don't have enough staffing to deal with those volumes of cases. And when we don't have enough staffing in our public defender's offices, where we have public defender's offices, that does put extra pressure on the panel attorneys who are taking appointed cases. So it is the number of attorneys that we're able to get onto the panel has definitely been helped by having this additional rate. It's not going to solve our problem overall because we do need additional actual caseload help with our public defender's offices and with being able to cover cases across the state. But it's a piece of that.
Another issue, and I'm not sure everyone is aware, but yes, there is a rate. And if the attorney who handles the case goes to the district court judge and they've gone over the budgeted cap and asks for a exceptional circumstances order saying, look, judge, the cap was X amount, and I went over that because for these reasons, and could you order that my voucher be paid as it is? Has the increase in hourly rate slowed that down a little bit? Because I'm trying to get the big picture of what your budget and how much money you're spending on cases. Because some counties, every voucher, every exceptional circumstance order that I would take would be signed, and you get so you're paying more than the cap. Not, I mean, there's two parts to this. There's the cap and there's the hourly rate. And so, could you talk to that a little bit?
Yes, I can kind of give you a quick overview of what that interaction is. So we have our hourly rate that pays per hour, and then we also have our reasonable rates of compensation caps that are included in our regulations. Our board recently went through those regulations and are in the process of asking for amendments to those regulations through the regulatory process in order to better account for the amount of time that is expected to be able to comply with the reasonable ethical provisions under Strickland v. Washington for a reasonably effective assistance of counsel, so that those caps more accurately reflect that, because right now our reasonable rates of compensation do not reflect that. And so we're in the process of raising those. In the meantime, however, because those rates that were currently in our regulations are based on the $80 an hour rate, we do have a significantly higher number of exceptional orders that are being signed because we're reaching those caps a lot quicker with $120 an hour. Thus far, we've not gotten a lot of pushback from the judges on their understanding that part of the reason why people are getting to those rate caps sooner is because of that $120 an hour rate. The combination of putting that in the statute and then fixing the reasonable rates of compensation caps through the regulatory process that we're proceeding through now should make those exceptional orders a lot less frequent and will also account for reasonably effective assistance of counsel expectations.
I just also wanted to clarify that, there's lots of times when attorneys are doing the effective rate is actually a lot lower than the published cap rate, because they're doing much more work than the rate cap, the total cap. And so they do a lot more work. They just don't bill for it because I've reached my cap. And so their effective rate may be a lot lower. Is that an accurate?
That's correct. And one of the problems with that, though, is that limits the amount of cases that they can take on appointment, because they're basically doing a large number of hours for free if they're doing that way. So by having more reasonable hourly rates and more reasonable compensation rates, hopefully will allow them to take as many cases as they can. And, if they're still taking some of those hours pro bono, that's fine, but they're not in a position where it's significantly limiting the number of cases they can take for that reason.
Yeah, I just want to make that point, because sometimes when you think about $125 an hour, people go, wow, that's actually quite a bit. But I just wanted to make sure that people understood that a lot of the time that may be the legal rate, but it may not be the effective rate given the number of hours you put into a case.
Okay, thank you, Heather. Next, we have Joe Molina.
Good morning, committee. Chairman Patton, Joe Molina with the Kansas Bar Association. We appeared on this bill last year when it was House Bill 2363, and we're very happy to appear for it again this year and 2351. We've been talking to Bids and Heather Cessna for a number of years now, and we recognize the needs of that office affects the entire criminal justice system. If there's no public defenders or criminal defense counsel to take cases, then everything stops. And so this bill actually will help rectify some of those things. It's important that we get it codified and put into statute, because if we don't, it goes back to 80, and then we'll see a massive exodus from the boards. Getting it to 120, I believe, is the appropriate number for the time being. As Heather said, maybe in the future we come back with a little bit different number, but for right now, I think that's something that seems to be working. I believe in 2017, the Kansas Bar Association did our economic survey of law. We went around, we polled all of our members. We're in the process of doing that again. I believe this is a little dated, but when we did this economic survey of law in 2017, the average hourly rate for criminal defense counsel was $225 for private. So we're still going to lag behind, but I'm not expecting $225 for appointed counsel. I'm just saying that's what a private counsel would charge according to our survey. And I'm pretty sure we can all agree that that price probably hasn't gone down. So I'm happy to stand for questions. I just want to make sure that the committee was aware that KBA is looking at this. We support bids and their efforts, and happy to stand for questions.
Any questions? Representative Mon.
Thank you, Mr. Chairman. Joe, do you know what the federal rates are for court-appointed counsel at the moment?
I do not. I can look up there and get them back to you.
All right.
You do. More?
Do you?
162.
Right. Thank you, sir.
Yeah, going over. Okay, thanks, Joe.
Thank you.
Any other proponents? Any neutral or opponent testimony? Seeing any, I'll close the hearing on House Bill 2351, open the hearing on House Bill 2409, and ask Natalie to come up and give us an overview.
Thank you, Mr. Chairman. House Bill 2409 enacts the Kansas Uniform Parentage Act, the 2017 version, and it repeals the current version of the Kansas Parentage Act. You have my bill brief, and I don't know that you really want me to go into the detail of going section by section on this bill because it is quite large. So I'm just going to kind of go over the 5 sort of big things that kind of change between this act and the act that we have in current law. So the act is updated to provide for gender neutral language throughout the act. It also contains de facto parent provisions when that person has been acting as a legal parent for quite some time. It contains provisions precluding a child-parent relationship from being established when the child is conceived by a sexual assault of some kind. So it kind of gives some guidance there. It also has some more pronounced surrogacy provisions. And then there are quite a few provisions related to assisted reproductive situations where a child is conceived, establishing parentage in situations where a child is conceived not through sexual intercourse, but through assisted reproductive science. So if you have any specific questions for me, I can take them. But I know the Uniform Law Commission is here and the Judicial Council is here, so you have that information.
Any questions for Natalie? Representative Owens.
Thank you, Mr. Chairman. Is that who this bill was introduced on behalf of? Was the Judicial Council?
Representative Patton actually requested this bill, and it came from a Judicial Council report.
Okay, very good. Thank you.
Thanks for clarifying. I couldn't remember how it got here. Representative Humphreys.
Thank you, Mr. Chair. So, I quickly got down those 5 things. Was the 4th one surrogacy? I think that's what you said, but I wanted to make sure. Mm-hmm. And can you maybe just say which section that was in? And really all of them. I don't know if you have it broken down like that, but
my brief generally has it broken down by that. I know the Judicial Council report goes through it, which I didn't bring up here. But let me find out exactly which provisions those are. If the proponents don't touch on it, I'll find the exact section numbers when I'm sitting down there.
Okay. And then, it seems like genetic testing is like section 27 and then 28 and
Yeah, the
39
genetic.
and 40. So is that where does that fit in on your 5 things, or is that already in there?
There already are some provisions in the current Parentage Act related to genetic testing. In the new act, that's sections 27 through 38. So that's where those will all be, located.
Did that fall under any of those 5 things that you mentioned?
Well, there are some changes in there related to assisted reproduction there for genetic testing, when it can be used when you're dealing with a donor type situation. So I think primarily the updates to those are related to that, but I'm sure the proponents can go into more detail about that.
Thank you, Mr. Chair.
Any other questions for Natalie? Thank you, Natalie. For proponents, Ron or Libby? Who wants to go first? Ron? Okay. Ron Nelson.
Thank you, Chair. Thank you, committee. First of all, before I really begin, I will address the questions by Representative Humphreys. The de facto parenting is not in this bill. Also not in this bill are provisions regarding surrogacy. Judicial Council didn't, although those are included in the Uniform Parentage Act 2017, Judicial Council decided not to include those in the proposed bill. Yes, so they are not included in this proposed bill. The provisions of this bill regarding assisted reproduction are in this bill. Right off, I don't remember the section numbers, but it's in the later sections of the Uniform Parentage Act. The surrogacy provisions in the Uniform Parentage Act are in Section 8 of the UPA, which was completely excluded. Moving on. This bill is part and parcel of a long-term project by the Judicial Council Family Law Advisory Committee. Starting about 14 years ago, the Family Law Advisory Committee started looking at Kansas family law statutes, including divorce, parentage, and others, that resulted in a recodification of the family laws in the current family law code, which is found in Chapter 23. That recodification took statutes out of Chapter 60, Chapter 38, which is where the Parentage Act was, and then some other chapters around in the Kansas statutes. At that time, there was discussion about what to do with the Kansas Parentage Act provisions, which came from the Uniform Parentage Act 1973. The Uniform Parentage Act provisions of 1973 were originally adopted by the Kansas Legislature in 1985, but at that time, the UPA was kind of taken apart, I guess is a good way of saying it, because since there wasn't a codified version of family law, there were all sorts of additions to the Uniform Parentage Act 1973 that had to do with child custody provisions specific to Kansas, child support provisions specific to Kansas, other things like that. Part of the Judicial Council's plan for this 14 years has really been to go area by area and revise, change, modernize, update all of those statutes, really look at what needed to happen, what updates in law there is, considering case law, considering different other changes. And that is what this bill does. There are some additional things that we did, that the Family Law Advisory Committee did in this bill. One of those very minor matters that was of some significance was that current Kansas law requires that a Kansas judge sign off or basically notarize an acknowledgement of parentage in a parentage case. Judicial Council decided that really isn't a judicial function. That's really not something that our judges should be doing. And so we took that out, adopting the Uniform Parentage Act 2017 provisions. I will say that this is the 2017 version, which the Uniform Laws Commission did a multi-year study on. There had been a version in 2002. There were changes in federal law and technology between 2002, 2017 that were incorporated into 2017. And so that also is what Judicial Council looked at, updates to federal law, requirements of federal law that were not in Kansas law, either through the Uniform Parentage Act 1973 or glommed onto it, either in 1985 or since. An administrative procedure of recognition of parentage, things such as that. With that background, I will stand for questions.
Questions, committee, Representative Carmichael.
Thank you, Mr. Chairman. Mr. Nelson, I always appreciate your assistance to this committee. And you're one of the leading practitioners of this area of the law, so I respect your opinions and appreciate the assistance. But I have to write something called a bill brief, and that's to describe to my caucus in summary fashion what's in this bill. And I have to be able to go out and justify this to my colleagues, who some of which are set in their ways and probably don't want to see changes in the law because we've always been doing it this way. But so far, the only thing I've got on my list that was changed by this is eliminating the requirement that a judge witness an acknowledgement of parentage. Are there other major changes being made in Kansas law by this 42-page bill?
There are not, and that's what we tried to do. Originally, when we first approached this project in 2018, we looked at whether the existing parentage statutes could be amended and changed, or if they needed to be changed. After looking at excuse me, the current statutes and comparing it with the UPA 2017, the committee decided that was not a good solution, that there were too many changes that had happened in the 30 plus years since the legislature passed the Parentage Act originally, and trying to just fit things together, reword, look at the Kansas Court of Appeals and Supreme Court decisions, really to incorporate into the Kansas statutes a lot of what that case law says. One of the examples that is not a change in Kansas law, but is a change of statute, is that the Kansas courts, since the 80s, there is a case known as the Ross case, in which the court is to appoint a guardian ad litem in order to look at what the best interest of the child is in context of contested parentage, where there's an additional parent alleged. That is not in the language of the UPA 1973. That was something that the courts looked at and included as a requirement, just because that is the best thing for the child, and that is a way to assist the court. The UPA 2017 includes specific provisions almost identical to what the Ross case talks about in order to address those issues.
So just to try to make sure I'm clear here, we've had the current Kansas Parentage Act since '83, or a period of 40 years.
Approximately, yes.
And it was based on a 73 Uniform Heritage Act. But over that period of 40 years, just by happenstance, Kansas case law and occasional tweaks here and there has created a statute that just happens to be virtually the same as the Uniform Heritage Act of 17, except for de facto parenting and surrogacy.
Well,
Did it just work out that way by luck?
no, it doesn't. That's how the UPA 2017 comes about. That's what the Uniform Laws Commission does, is looks at the development of law across the states in order to determine how the previous uniform laws should be altered in order to keep up with current technology, current practice, current case law, the advancement of the rights of children and looking at the rights of parents all together. And so that's kind of how the courts have done it without the language in the statute. The language that the Uniform Laws Commission really tries to be uniform across all of those states that enact it. And so it's not really by happenstance. It's kind of a coming together.
Okay, I'm going to enjoy some more chocolate, Mr. Chairman. Thank you.
The chocolate, by the way, is compliments of the vice chair. His phone rings a lot in committee, so he brought chocolate. Any other questions? Representative Humphries.
If we could just clarify a little bit. At the beginning, when you had mentioned the not the de facto parenting or the surrogacy, but I so trust Natalie. You have to understand. I've known you for quite a while, but I've known Natalie too. So can we have some sort of I just would like to understand a little bit better what you mentioned or maybe what Natalie said.
Mr. Chairman, so if you were to, so the brief that I have goes section by section and goes through in an effort to kind of not drone on forever, I just gave the Uniform Law Commission summary, which typically works out, but those provisions were not in the Judicial Council version. And so that is where that misstep is. So those provisions are not in this bill brief. They're not in the bill. But the assisted reproductive rights sections are, which is, yeah.
Okay, thank you, Natalie. And so did the committee, remind me, chose not to put the de facto parenting or the surrogacy in their Judicial Council report?
Yes, that's correct.
Okay, thank you.
Well, and I will add to that, if I may. The Judicial Council written testimony does include the Uniform Parentage Act 2017, including the Uniform Laws comments as well as Kansas comments. And so if you look at Article 8, you will see that all of that is stricken, and there's a Kansas comment explaining that surrogacy was excluded.
Yeah, okay, thank you. Thanks. Appreciate that. Thank you, Mr.
Any other questions? Representative Titus.
Thank you, Mr. Chairman. So is the main benefit of this just reorganizing the statutes? I want to simplify it, but that's kind of what I'm hearing, which is fine. I just want to make sure I understand.
That is one of the benefits. There are a number of additional small benefits or technical benefits, that one being that judges don't have to witness. So that's just one example that came off the top of my head. And a lot of it is rewording, redrafting, and just making sure that we move ahead from the 1973 version so that it's more clear, so that we keep up to date and don't have an almost 40-year or a statute based on an almost 40-year proposal.
Okay, do not see any more questions. Thank you.
Thank you, Chair.
Next, we have Libby Rosen. Libby Snyder. Yeah, sorry. Libby Rosen, that's Chief Justice, or Justice Rosen's wife that I talked to the other night. I don't think she's here.
Thank you, Mr. Chairman. And thank you for considering House Bill 2409. My name is Libby Snyder. I'm a staff attorney at the Uniform Law Commission. I'm mostly here to sort of talk about the Uniform Law Commission's process for creating and developing these uniform laws, which the Kansas Judicial Council then took and drafted in a Kansas-specific way for the committee to consider. The Uniform Law Commission has been around since 1892, and we were formed by the states to draft model laws in areas where uniformity among the states is advisable or necessary. We have commissioners from all 50 states, the District of Columbia, the Commonwealth of Puerto Rico, and the U.S. Virgin Islands. Our commissioners are all attorneys appointed by the governor, by the state legislature, and we have about 400 commissioners. And they all sort of come together to, create, develop, study, and then draft uniform laws in areas that are very technical and benefit from like a long process with a lot of expertise. The process begins with a proposal that comes in. It can be from one of our commissioners or from some outside organization, a law professor, practitioners, anybody can submit a proposal. And that's considered by our Committee on Scope and Program. That committee may choose to appoint a study committee, which will take 1 year to look at the topic generally and decide whether or not drafting uniform law would even be beneficial or is necessary. After a full year of studying, they may decide to move forward to drafting a uniform law. And if they make that step, the drafting process takes a minimum of 2 years, and it's an open process, open to the public. Uniform Law Commission staff or the drafting committee chairs will seek out organizations and other areas that may have an interest in the area for which we're drafting and invite them to participate so that we have everybody at the table who needs to be there, who may have a stake in the final law. That process takes 2 years. It's considered by the Uniform Law Commission as a whole, all 400 commissioners. They read it line by line at least twice to go through it and find, little errors, areas where tweaks in the language could be beneficial. And then after that 2-year long process, or 3 years long minimum, it would then go to the states for consideration and possible enactment. And then that is where the Kansas Judicial Council picked it up in 2018 to look at for several more years to decide if the UPA 2017 was a fit for Kansas. Sort of some history on the Uniform Parentage Act. The first draft of that act was in 1973, but this is an area of law that the Uniform Law Commission has been involved in since 1922, so over 100 years. When we first drafted the Uniform Illegitimacy Act of 1922. There were several other iterations of uniform laws between 1922 and 1973 dealing with parentage and different things in that area of law. But the uniform laws in that subject matter area didn't see wide enactment until the UPA of 1973, which Kansas enacted in 1985. The UPA was updated in 2002 to add provisions permitting a non-judicial acknowledgement of paternity procedure that's the equivalent of an adjudication of parentage in a court. And Kansas didn't enact that version because in 1994, you all amended your statutes to add in a similar procedure that Mr. Nelson spoke about earlier. The UPA 2017, clarifies and codifies different advancements in family law that were happening in the states in, different judicial opinions and little tweaks to statutes in the time ensuing. What it does is it presents a very organized and clear, concise method for determining parentage in many different scenarios. And incorporates different areas of case law that could be beneficial to incorporate in statute. With that, I'll take any questions about ULC process or the background. I'm happy to be here.
Questions, committee? Okay. Representative Humphreys.
Thank you. So just looking at your testimony, you talked about the Title 4D funds.
Yeah.
And so do you know, can you explain that just a little bit more? Are you, have there been states that have not adopted the 2017? I mean, is the federal government withholding any of those funds? I mean, or incentives, or can you just that paragraph? Can you just explain that a little bit?
Absolutely. Thank you for the question, Representative. States do not have to update or to enact the UPA 2017 to receive those funds. But what it does is that the UPA 2017 was drafted in conversation with the Federal Office of Child Support Enforcement to ensure that any states that do adopt the UPA 2017 will be in compliance with federal law and will receive those funds. And so it's not that your funds will not be given to Kansas if you don't enact it, but it's that if you do, the language in here is sufficient to comply.
Thank you. Thank you, Mr. Chair.
Do not see any additional questions. Thank you for coming.
Thank you.
Any other proponents? Any neutral or opponents? Okay, close the hearing on House Bill 2409 and open the hearing on House Bill 2293. Have Natalie come back up.
Thank you, Mr. Chairman. In doing my research for the Carmichael question, I inadvertently sent you the brief for the bill number of last year's bill of this. So you have the auto expungement bill brief in your inbox from Kathy, but she has the updated one. So I'm sure she'll be sending it to you soon, hopefully, when she can do that after the hearing is over. But House Bill 2293 creates guidelines for introducing testimony of jailhouse witnesses in criminal prosecutions. The bill would add a new section of law. Subsection A requires prosecutors to disclose their intent to introduce testimony of a jailhouse witness regarding statements made by a suspect or defendant while that witness and suspect or defendant are both incarcerated. The prosecuting attorney would be required to provide to the defense the criminal history of the jailhouse witness's cooperation agreement, and any benefit that may result, the contents of the statements that were allegedly made, any information regarding the jailhouse witness recanting, and any information on other criminal cases in which testimony of that jailhouse witness was introduced or intended to be introduced. The court can extend the time for the prosecutor to comply if the witness was not known or the information cannot be discovered within the statutory time period. And if the court finds that disclosing the information is likely to cause bodily harm to the witness, then the court can order that evidence be viewed only by the defense counsel, or they can issue a protective order. Subsection B provides that in a criminal prosecution for murder or rape in which the prosecuting attorney intends to introduce the testimony of a jailhouse witness on motion of the defendant, the court can conduct a pre-trial hearing to determine whether the witness's testimony exhibits reliability and is otherwise admissible. This subsection also lists the factors that the court shall consider and provides that if the prosecuting attorney fails to show by a preponderance of evidence the testimony is reliable, then the court would be required to exclude that testimony at trial. Subsection C requires each prosecuting attorney's office to maintain a record containing information on any case in which testimony of a jailhouse witness is introduced or is intended to be introduced, and any benefit that is associated with that testimony. The prosecuting attorney's office would have to forward that information to the KPI, who then would maintain a statewide database of that information, and it would only be available to prosecutors and is otherwise confidential. Subsection D provides that if a jailhouse witness receives any benefit in connection with testimony, then that prosecuting attorney has to notify any victim connected to the criminal prosecution. Subsection E provides that if the testimony of a jailhouse witness is admitted into evidence, then the jury has to be instructed that testimony was provided by a jailhouse witness and informed of any benefit associated with providing that testimony. And then in subsection F, we have definitions of what a benefit is for use in the bill, and also a definition of a jailhouse witness. And I can take any questions.
Representative Carmichael?
Thank you, Mr. Chairman. Ms. Scott, this bill seems very familiar.
It sure is.
I think we've seen it before. Do you happen to recollect when, where, and the fate that it might have met?
Yes. So you guys did hear this issue last biennium. It was House Bill 2366. It passed out of this committee. It also passed the House 123-0, and then it died in the Senate Judiciary Committee.
That's where good ideas go to die. Thank you, Mr. Chair.
Any other questions for Natalie? Okay, thank you. Again, with proponents, and I assume this is the order you want me to go. I have Bay Scoggin.
Let's raise this up a little bit. Hello, good afternoon. Thank you. My name is Bace Goggin. I am state policy advocate with the Innocence Project. And yes, indeed, this should be very familiar to you, so I won't belabor it. Natalie did such an excellent job talking about it. I think the key points here to remember are that these types of testimonies are inherently the riskiest testimonies that a courtroom will typically see. So these pretrial reliability hearings that you might use for an expert witness testimony seem to make sense for these incentivized testimonies, and at the very least, a disclosure of the type of benefits received, I think, is crucial. So I thank you for your previous support. I'll also add one key component of this that I think is really great, and that's the notification of victims. And so that piece of the proposed legislation would notify victims if the individual related to that crime is one of the people giving jailhouse informant testimony. And so I think the last thing that we want to see is a re-traumatization of those victims with leniency or other benefits given to people, especially if that leniency leads to a wrongful conviction. And what we've seen in our time in the last 20 some odd years of doing this exoneration work, 30 some odd years now, is that about, of DNA related cases specifically, about 15% of them included jailhouse informant testimony that led to the wrongful conviction. When you look more broadly at all of the exonerations tracked by the National Registry of Exonerations, that number is a little bit lower than 10%. It's about 212 of the 34 some odd hundred exonerations that we've seen. And so this is a clear piece that we see in wrongful convictions time and again. And one of the things that keeps coming up is that a lot of these individuals continue to be a resource and continue to give testimony. And so that's really one of the things that we're working to limit is the repeated benefit, this cycle of incarceration and benefit from testimony that leads to perhaps an early parole or something of that nature. So I won't go any deeper into that, but I am happy to stand for questions. And I'll just say that sometimes when you lose, you have to come back to the Super Bowl and win the next time around. And so many congratulations to the Chiefs fans. I assume there are a few in the building.
Any questions? Representative Lewis.
Thank you, Mr. Chairman, and thank you for the testimony. I'm new to the committee, so some of this stuff I'm sure was gone over in the last session or so, but I'm just curious to what extent is what is being proposed to be codified is the practice in prosecutors' offices and in the courts of the state already?
I think it's a really good question. And we've met with the prosecutors to discuss this bill. And I hope that you'll hear some good reports on that from them. What I will say is that the rulings about the Brady disclosure requirements are fairly clear, but that this bill would codify that statute to be a part of the process earlier on, which is an important component for defense to be able to get ready to challenge or disprove some of the credibility of the jailhouse informant testimony. And so really what we're just trying to do is codify the disclosure requirements that are already largely recognized by the federal judicial system.
I guess my comment is that makes sense because it would also help prosecutors to know more precisely what the rules of the road are.
Precisely.
The codification would do. So thank you.
Thank you for helping me make my point better.
Representative Carmichael.
Thank you, Mr. Chair. You are Mr. Scoggin, is it?
Yes, sir.
Okay, I apologize. I wasn't paying careful attention as you were being introduced, but I do have that bill brief I have to do, so I want to make sure I get your name correct. Okay. I'm particularly interested, though, in talking to you about this pre-screening process involving the credibility or lack thereof of a jailhouse informant, witness, otherwise known as a snitch. It's by a preponderance of the evidence that the court has to make a determination. Is that correct?
I'm going to defer to my expert witness testimony that's going to come up, but her reliability is unimpeachable.
Then let me hold my questions for a later time. Thank you.
Thank you, Representative.
Any other questions, committee? Okay, thank you.
Thank you.
Next, I have Tricia Bushnell. A little shorter.
A little height differential. Thank you, Chairman Patton, and thank you, committee, for yet again allowing us to present this bill before you today. My name is Tricia Bushnell. I'm the Executive Director of the Midwest Innocence Project. And we, along with our partners, have represented a number of individuals who've been exonerated here in Kansas, including most recently Pete Coons, whose case involved the use of jailhouse informant testimony. And for those of you who were not here at the last hearing that we had, Pete Coons' family also testified in support of this bill, and Pete himself would be here to testify in support of this bill, but unfortunately he passed away 108 days after his release because of cancer that went undiagnosed. So, I won't repeat what my colleagues have said before, but what I can say is we know that this is something that has happened in the state of Kansas. If we look specifically to Pete Coons' case and the use of the jailhouse informant testimony there. I want to jump a little bit, Representative Lewis, to answer a little bit of your question about what is it codifying of Brady. And I think it's exactly what you're saying. It's not just that it's codifying what the standard is, but it's making clear what that requires. Because if we don't make clear what disclosure is, we're actually asking prosecutors to put on the hat to be both the prosecutor and the defense attorney and do more work, which is just substantively very hard. And the reality is then when somebody on post-conviction comes by later and finds that their reasoning at that time wasn't accurate, then we have a post-conviction claim, right? The goal of this bill is to create reliable testimony. It doesn't prohibit the use of a jailhouse informant. It just requires that we put in these provisions that make it reliable so that we can be sure that Kansans are convicted on reliable evidence. And also, as I like to joke, I can work myself out of a job. But when we look at those issues and we add in these provisions of tracking and enhanced disclosure, one of the issues that Representative Carmichael was just mentioning is the reliability hearings. So I won't repeat all of the wonderful phrases that Natalie said, but the pretrial reliability hearing is something that's requiring the judge to then say, we believe that this is reliable. You're bringing me a jailhouse informant, right? I'm informed of all the issues that are in front of it. I have evidence that shows whether it's corroborated or whether this makes sense and whether the jury should hear it. And I bring that up because it's not something that is new in the area of law. We have pretrial reliability hearings on scientific evidence all of the time. So, we obviously support this bill. We thank you again for hearing it, but with that, I'll take it for questions rather than sort of belaboring the news that you already know.
Questions? Representative Carmichael.
Thank you. I appreciate you being here. You all have obviously accomplished good things in my state, and I appreciate your work. The matter of the pre-trial determination of credibility of a jailhouse informant or witness, it's a preponderance of the evidence standard, as I understood it.
Yes, that's correct.
And is the burden of going forward, if you will, with the evidence to prove reliability, is it the state's burden or is it defendant's burden to go forward to show by a preponderance of the evidence that the proffered witness is unreliable?
So, the burden would be on the state because that is what we require in the burden of a conviction, that they are using reliable evidence, that the evidence that they would like to put forth to secure that conviction meets the standard of reliability.
And is that in fact specifically in the bill? The reason I say that is if we were to really draw that analogy from the burden on the state, one would think that it would have to be beyond reasonable doubt, and I'm not advocating for that.
So there's a difference in the standard of what they have to prove to a jury to secure a conviction, and then just what they have to prove in order to get the evidence in front of a jury, right? And so that's when I point to these kinds of reliability standards we use in other instances. For example, when we use scientific evidence, the judge is making a determination, yes, this is scientifically valid evidence, the jury should be presented with it now, but it is still the obligation of the prosecutor, right, or a plaintiff in that instance, to meet the burden of what the conviction is to the jury. So it's okay to have these different standards because that evidence itself may not be alone enough to secure the conviction.
But the gatekeeper function, if you will, for the judge to make an initial determination of credibility, the burden rests upon the state to demonstrate the credibility, or the burden rests upon defendant to say, yes, every man brings his evidence, but this one here is an unreliable one, and here's why, Judge.
Yeah, I certainly, It's an interesting question because also it raises an interesting question of what if a defendant ever wanted to use a jailhouse informant? Not that we see that very often.
Indeed, and you're anticipating where I was eventually going to end up was whether or not defendants' ability to offer witnesses would be limited. Would this be a bilateral, if you will, application? So help me with all of those.
Yeah, I think in terms of the purpose of the bill, which I think is going to be most helpful in understanding where we want to go with it, when it comes to the pretrial reliability, if, for example, a defendant did want to bring in a jailhouse informant, someone else who's incarcerated, right? Certainly, we would say that it would be on their burden as well to prove reliability, whoever wants to introduce the evidence. Now, the difference is a defendant doesn't have the ability to offer an incentive to someone else who's incarcerated in the way that the prosecution can. Right. And that is what is at the heart of this bill is how can we make sure that the jury and that everyone knows that there may be these incentives that only the prosecutor can know because only the prosecutor knows those communications and other activities that they've had with that jailhouse informant.
Finally, Mr. Chairman, so you would contemplate a circumstance where in a pretrial hearing, a prosecutor would have to file a motion, obviously disclosing this and seeking an evaluation by the court regarding the credibility pursuant to whatever statute it is. The prosecutor would then come in and present their evidence. The defendant could stand moot if they chose and present no evidence, and the court could say, you've not brought me, Mr. Prosecutor, enough evidence to persuade me that this is a credible or reliable witness. Is that the way it works?
Yes, and I actually think there's some really interesting cases that we can look to around the country that would support a judge being able to make that finding even if the defendant did nothing. For example, I can think of a case that I had of a client in Arkansas where someone came forward and said they knew about a crime, but they couldn't get the weapon right. They couldn't get anything right. And so a judge could say nothing here is supported by the other evidence that's being presented. So this shouldn't go before the jury.
We could talk about the reprehensible practice, though, of some prosecutors in days low, many, many years gone by, who managed to provide that information to the jailhouse informant so that they would know the facts that only the defendant and the investigators knew. It was a reprehensible process that I saw with my own eyes. Thank you, ma'am.
Thank you.
Any other questions, committee? Representative Munn.
I understand the intent of this. I do have a question about, is there any provision in the bill to protect the identity of the jailhouse informant? So, for example, if a prosecutor prophylactically wanted to file the motion, give the information, but was going to be, obviously they may choose not to proceed with that witness at another time. So now there's a public record disclosing the identity of somebody who's in custody who is now going to be labeled a snitch, even though their testimony doesn't ever get used.
Yes, the bill does provide a safety mechanism for that. So where there are concerns about safety or bodily harm, the court can order that the disclosure is only an in-camera review. So the defense attorney would come in and meet with the judge and learn that information, but it's not anywhere else where someone else could get that information.
Any other questions? Okay, thank you. Committee, you have written proponent testimony from Michael Austin with Americans for Prosperity, Kansas. Any other proponents? Okay, not seeing any. At this point, we're pausing this hearing. Oh, yeah, come on up, Clayton. By the way, I sent you an email a little bit ago. Different topic.
Yeah.
Get back with me.
We did submit written testimony on this. I'm not sure it wound up on the agenda. Is it okay that I...
You're not, but go ahead and let's just double check afterwards to make sure we got it.
Yeah. Clayton Perkins, on behalf of the BIDS Legislative Committee, we are also proponents of this. And the only remark I'll add to this discussion is I would suggest the committee consider a friendly amendment to this bill, which would be to, on that pre-trial reliability portion on page 2, lines 10 to 16, inserting within the list of crimes that qualify. It's currently murder or rape with the statutory numbers. I would include aggravated criminal sodomy in the list there, which the Kansas Supreme Court in the State v. Denny case found it violated the equal protection components of our Constitution to not include that in our post-conviction DNA testing statute.
Any questions, committee? Okay, thank you. Any other proponents? Okay, if not, we're going to pick this hearing back up on Wednesday. Neutral or opponent, I'm not sure. Testimony, the conferees were not available today, so they asked if I could put this on pause and we'd come back to it. So we're going to do that. That's all I need to do. Okay, that is it for today. Tomorrow we have one likely very short hearing, and then my intent is I hope to be able to work House Bill 2023 again. That is the bill that created the crime of interference with the conduct of a hospital, et cetera, that we passed out. It got sent back to us to potentially address some concerns by a member, and we'll see if we can get that resolved and sent back out. But since we have a little time tomorrow, we'll take that one up. And then I will try to tomorrow have a list for you of what bills we might get to later this week and potentially early next week. So that's it. Everybody have a good evening. We're adjourned.